Welcome back. You're all cold?
Yes.
Yes.
Whoops. I always wear a suit even when it's hot out.
He's just picking on
Never hot in this room. I am. It's fun. I don't get to do it often, except the game last. Never mind. Okay. Ooh. I'm actually flying to New York tonight, so I'll be in the air during the next game. I won't be there in time to go see it, but I'll actually be home. I think in time for game 7. Anyway. So any questions? I'll send out a link probably next week or so with times to sign up. Over 100 slots, so be sure to do it. I'll say this much. I gave you one piece of advice for the exam, to take old exams you know I'm looking for. Some of you took that advice, some of you didn't. It's very obvious. Some of the answers look like they're supposed to look, and a lot of them didn't. So I can tell right away that the advice made it partially effective. Okay, I'm going to turn this off. Okay, and I want to start off with a question for today. Okay, this is your question for today to start off. Okay, following the New Deal, the Supreme Court abandoned the approach of substantive due process that it had used during the Progressive era. That's your question. Following the New Deal, the Supreme Court abandoned the approach to substantive due process that it had used during the Progressive era. All right, another 10 seconds or so. All right. Where was I last time? Who's next? Yes, sir, in the back. What's your answer? You only have 2 choices, right?
Yeah. I mean,
That's why I asked the question like this. What's your answer?
I put true.
Put true? Okay, why'd you put true?
Some of the decisions I felt like they took where I felt like they looked at the due process, but what the Supreme Court was specifically kind of, I guess, took it upon themselves to, I guess, distinguish what was due process and what wasn't, I guess, a violation of due process, and they themselves were kind of, I guess, judging on the constitutionality of the certain statutes that were passing. So I felt like the Supreme Court was kind of themselves, I guess, separating away from.
Evan, what's your answer?
I put false.
Okay, why'd you put false?
False because it doesn't look like the court kind of used this agency process pretty consistent in my eyes, pretty consistently up until these newer cases that I'm going to read today, and they didn't overturn. They didn't start saying we're not really using that process anymore until.
All right, Adam, let me ask you this question. What was the approach?
You know, I had the same answer.
Oh, I haven't had it before. I don't get it. Don't try to tell me this is for trained professionals. What was the seriously? It's not. Go back and watch my lectures my first year. It didn't look like this. It's that much better. I actually, when I started teaching, I think my first graduating class, my second or third year, when I brought students, like, I'm really sorry. It got much better, guys. But Adam, what was the approach used during the Progressive era with respect to substantive due process? Describe it to me briefly. What was that approach? And by the way, this is a sort of exam question you need to know. I'll say you're in the Progressive era in the 1920s, 19-teens, and you have a due process case, you have to know what to do. So that's my question to you, Adam. Describe for me the substantive due process approach used during the Progressive era.
I really don't have a good answer for that exam question.
What were your readings for today? What time period were your cases today from? When was the progressive year, Adam?
1940s and 50s?
No. When was the New Deal?
The New Deal was right after the, it was the 1930s.
Okay, good. So, based on the grammar of that question, did the progressive year come before or after the New Deal? Based on the grammar of the question, and nothing else. Census.
After the New Deal?
No.
Before?
How can the court abandon something that hasn't happened yet?
After the New Deal?
No. How can the court abandon something that hasn't happened yet?
Can't.
Can't. So when did the progressive year happen? Before or after the New Deal?
After?
Oh, you better know. Brandon.
Before.
Before, yeah. The progressive era was generally the early 20th century. 1910, 1920. New Deal was the 1930s, right? And the question is this. In the 1930s, did the court abandon substantive due process jurisprudence it had during the progressive era? Brandon, what's your answer here?
Well, it restrained the states. Let me think through this.
What was this due process framework using the progressive era? Describe it for me.
Wasn't the due process framework used to restrain the power of the states?
Good. And how did the Supreme Court apply it? Give me some examples of the way the court applied it.
Like on the minimum amount of work hours for women.
Okay.
People in a bakery, who work in a bakery.
Right. And what did the Supreme Court do with that?
They said that it was okay. It's okay for the states to do.
What was the holding in Lochner v. New York? The bake shop case. What was the holding there? Oh, come on, guys. This is not good. What was the holding in Lochner? We spent an hour on that case.
That they couldn't regulate the hours.
What was the holding in Lochner? Adam, redeem yourself.
Then unless it was an industry where government was naturally inherently dangerous, the government couldn't restrict the private business owners' right to.
Very good. So how would you then describe this court's approach to substantive due process during the progressive era? How would you describe
Hands
that?
off.
Well, was the court hands off?
Well, no, it was government shouldn't overstep its bounds.
Very good. So during the progressive era, right, the court used the due process clause to invalidate state and also federal legislation, social welfare legislation involving wages, hours, work conditions, and other things. Okay? That was the jurisprudence during the progressive era. And it was premised on the due process clause, the idea that there's certain liberty interests that the state cannot deprive you of that due process. And the court determined that these regulations were unreasonable. Now, why were they unreasonable? We've spent an entire hour on this. And the short answer is the courts found there wasn't a good fit, right? The state can protect health and safety, but if you have an occupation like baking, it's not particularly dangerous. Therefore, the court doesn't have a good enough reason to regulate the wages or the hours. Now, as we'll see later today, with the case of West Coast Hotel v. Parrish, that was something of an inflection point, where the court deviated from Lochner. In many respects, West Coast Hotel overruled Lochner. Not directly, but it did. Right? And Amber, what was the trajectory taken, starting with West Coast and also in Carolene products? How would the court apply substantive due process?
More, I guess, openly, like they allow for states to do more now.
What do we call that? How are the courts reviewing state legislation in that case? What adjective would you use there?
I guess more broadly.
Well, they gave the states more latitude, but how would we describe the standard review there? In terms of scrutiny.
I guess they were less strict on how they.
What do we call less strict? What's the word for that?
Um,
We've used it before.
I don't know, I guess.
What's the word for less strict?
I'm not sure what.
David? Said, no, that's not what we're looking for. Okay? We scratch it. Who knows what I'm looking for?
Liberal?
Not liberal. No.
Reasonable?
No.
Reasonable?
How about deferential? How about deferential, right? The idea of deference, right? The idea of deference is that the court will say, look, this is not our expertise. We are going to defer, right? Defer, deferential, to the government's arguments. We're going to defer. So starting with West Coast Hotel, the court became much more deferential. And they basically said, we're not going to be in the business of invalidating state laws under the Due Process Clause. We're not in that business anymore, right? That was what West Coast Hotels basically said. But the way I framed the question was a little bit devious. I did this quite deliberately. When we get to Carolene products, we see something else. The court saying, well, as a matter of course, we're generally not going to be strictly scrutinizing state legislation, except in certain circumstances, when certain rights are applied, when certain people are involved. So what the court basically said is, we're not going to use Lochner, right, unless there's certain rights that are important, and there's certain people that are worth protecting. So there was not a wholesale abandonment of Lochner's style substantive due process. Rather, they merely limited it to a fairly specific set of circumstances. So Lochnerism was truly never killed. They just maybe crippled it, right? They limited it to certain circumstances where Carolene Products described a heightened scrutiny should be attached, and the presumption of constitutionality should be reversed. But the general rule following the New Deal is state legislation, unless it touches one of these specific areas, is hands-off, or courts are not going to stop it. Okay? That will take even another turn in next class when we do the contraception cases and the personal privacy cases. But at least through the New Deal in the 1950s and 60s, the court was hands-off. Okay? So the answer to this question, pretty close, pretty close. I think the answer is actually false. The court never actually said we're overturning Lochnerism, right? We're not overturning the idea of substantive due process. What the court basically said is we won't use this unless specific circumstances are triggered. And that's Carolene Products in footnote 4. So I think it's false, but close call probably. The questions on that lead-off question. By the way, your need-to-know cases, in looking at your papers, very few of you cite cases. Very few of you discuss cases. All we do is talk about cases. That's all we ever do. When you just give me rules of that cases, that tells me you're probably copying from a horn book or something. Don't do that. I need you to talk about cases. That's how you get an A. Andre, you handing or are you just spinning?
No, I'm not.
Okay, so your hand's twitching. Okay. All right, so any questions before we get started? Okay, who's next? I think David, you're up. David, give me the facts piece of Meyer for Nebraska.
In Meyer versus Nebraska, there was a parochial school, and they were, teaching kids what parochial schools do. They were teaching both secular and religious education. But and then there was a student there that was having trouble reading, so the teacher was teaching him in German, but that there was a state law in Nebraska that said that you couldn't teach in the German language.
Okay, so let me pause right there. Why would there be a law which says you couldn't teach German? This is 22, 23. Why would such a law possibly be on the books? Yeah, why not? Yes, okay. So, but the statute wasn't just about German. What other languages were covered by it? Or what foreign languages were excluded from this statute? Let me ask a question like that.
The dead languages?
Right, so you could teach Greek, Hebrew, Latin, right? All other alien languages, all the foreign tongues were verboten. Oh, did I just break the law? They were forbidden, right? They were forbidden. Be aware. So German, French, Spanish, Italian, whatever, prohibited. This law was born of xenophobia. There's no other way to describe it, right? That's it. There was a desire not to have people under the age of 8th grade studying foreign languages. You can study Latin or Greek, that's fine, but you couldn't study foreign languages. And it was primarily German. That was the major issue. There were huge Slavic populations in the Midwest, and there was a desire to prevent them. By the way, this was a criminal statute, right? If you taught German, you went to jail. You probably also had the Scopes monkey trial, right, where you had a teacher who was teaching evolution in a school. Inherit the Wind was based after, right? You never heard of this case, did you? Of course not. It's the same agenda, but it's the same idea: throwing people in jail for teaching stuff. Same exact facts. It's actually striking how many of these cases were criminal laws. Leo Nebbia almost went to jail for selling bread for too cheap of a price with the milk, right? Lochner went to jail. Charles Hauser went to jail with Carolene products. These people are thrown in jail for doing stuff that you think is fine. Anyway, Boone. So this guy taught German. Teacher convicted for teaching a 10-year-old student about speaking German. Convicted of a crime. What is the argument that this conviction should be voided and nullified? What's the argument?
That it's a desirable end cannot be promoted by prohibited means.
No, give me that. What clause of the Constitution are they citing? We'll get there in a minute.
What clause?
What provision of the Constitution are they citing here in Meyer?
For the convicted guy's case?
Yeah.
For his team?
Yeah, what? You're his lawyer, right? What provision of the Constitution are you citing? You don't have many to choose from. What's the topic of today's class? Don't help. We're looking away. What's the topic? What clause of the Constitution are you citing in your case? Of which amendment?
14.
Yes. And what does the 14th Amendment due process clause say? You can paraphrase. Take your Constitution. You should know this by heart. At some point this semester. What's the 14th Amendment prohibit? What can the state not do? Section 1, 14th Amendment.
They're messing with his,
Read it.
all of section 1?
Just the due process clause, please.
All persons born or naturalized in the United
No, the
States.
due process clause. Do you know what that is? Let's read it.
Nor shall any state deprive any person of life, liberty, or property without due process of law.
Very good. Stop right there. Did the state of Nebraska deprive a teacher of life, liberty, or property without due process of law?
Yeah, if they're holding him criminally liable for something that he should have the liberty to do.
Well, how do you know he has the liberty to teach the German language? Where do you get that from? You read it again, it's not in there. There's no like little asterisk behind liberty, right? There's no ink blot. How do you know that the word liberty in that sentence includes the right to teach German?
I don't.
You don't. Jason, does the word liberty embrace a teacher's ability to go to school and teach a language?
According to the court, yes.
Well, where do they get that from? Where does Justice McReynolds get that from? You're right. The court does say that teaching is a liberty protected by the due process clause, but where does McReynolds get that from?
He says he gets it from slaughterhouse cases.
The slaughterhouse cases. I don't remember anything about teaching in that case, do you? It was about butchering, and I remember the butcher's lost.
But it defines, in his words, liberty may not be interfered with under the guise of protecting the public interest.
Yeah, but why do you know that teaching German is a liberty interest? Where does he get that from in particular? Slaughterhouse says nothing about teaching.
They invented.
Who's that?
The court,
The court invented the rights.
with their definition of liberty, is not one that's I've seen before, but they're saying that education is a liberty and the right to learn and better yourself, and for parents to be able to determine what their children learn.
Ah,
is a
so
liberty.
parents, it's not just about the teachers, but the parents also. Ah, okay, so let me read this to you, right? So what is liberty? I think I gave you the quote from Abraham Lincoln. My definition of liberty is not your definition of liberty, right? So Justice McReynolds wrote, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. Jackson, where the hell does he get that from? I read it, you read it too for class. Like, where does he get this from? He listed 10 or 11 rights. I mean, there's a lot of stuff there. Where does he get this from?
I mean, I could only guess probably from previous cases.
There aren't any other cases.
Okay.
Yeah, a good guess though. A for effort, right? I didn't see any citations there. There weren't any. Where's he getting this from?
It sounds like he's just making it up.
Is he? Brittany, is he making this up?
Well, it's so specific, I mean,
It's
a lot of different definitions of what he thinks liberty includes.
Where's he getting this from, Brittany? Let me ask you a question. You remember last week we did the Burlington case about the taking of the railroad, right? And I remember Justice Harlan said that no civilized government could ever take property without providing compensation. Remember we did that last week? Where did Harlan get that from? Was Harlan making it up? Was McReynolds? I mean, they'll just make crap up. Is that the rest for our semester? They're making crap up. But you get a point. You said they're specific, right? What specific thing looks there maybe a little bit familiar? I think you're onto something there.
They say those privileges law recognized at common law.
Oh. Well, let's help us out here. Where's McReynolds getting this stuff from?
I'm not entirely sure, but it kind of sounds like it refers back to the Civil Rights Act.
Oh, that's right. Remember the Civil Rights Act of 1866? The thing that came before the 14th Amendment? You're right. This is almost a verbatim list of several of the provisions. The right to make contracts, the right to pursue an occupation. What McReynolds is talking about are these sort of common law rights that were long understood, at least in the 1920s when this case was decided. This is the same basis that Harlan says, of course the government can't take your property without just compensation, right? That'd be insane. We don't have this understanding today of what these rights are, because our understanding of rights has been tainted by the Supreme Court. But at least McReynolds is saying there was this long-standing tradition. This case was unanimous. There was not Holmes with dissented, but it was only Holmes, right? But basically it was 8-1. All the justices more or less went along with this. Now, Kelsey, let me ask you this question. He lists a couple things, though. Worship God according to dictates of one's own conscience. This was, again, I think David said it a minute ago, this was a school. It was a religious school. And they were reading from the Bible. And they were teaching about Scripture. What provision of the Constitution would you think he may cite here when he's talking about worshiping God and conscience? Well, there's a provision of the Constitution that would seem a little more relevant than the nebulous due process clause. You haven't studied it yet, but you've probably heard of it. Yeah. Which part? Do you know? Well, worshiping God. Free religion, yeah, the free exercise of religion, right? Look at what they're talking about. Reading scripture, reading from the Bible. Right? Did you notice that the First Amendment's not cited anywhere in this case? Did you guys notice that? Especially in the next case, right? With the Society of the Sisters of the Nuns, right? Was the First Amendment cited anywhere? That basically the state was shutting down a Catholic school. That's what was going on. Now, Mark, bonus question, right? Why is the First Amendment not cited anywhere in either Meyer or Pierce, the Society of Sisters? First Amendment's not mentioned. He talks about religion, freedom, worshiping God. Why doesn't he cite the First Amendment?
Because there's a focus upon trying to differentiate the powers between.
Mark, let me ask you this question to help out. Why didn't Harlan cite the Takings Clause of the Fifth Amendment last class? Notice, Harlan did not cite the Takings Clause. Here, they do not cite the First Amendment, and Meyer or Pierce cited a couple years apart.
Maybe because they don't want to make the court into an extension of the church.
No, that's not it. Crystal, why is he not citing the First Amendment here? It's right on point, that freedom of exercise. It should be cited. Why isn't it? Why didn't
Will you repeat your last question, Mike?
Why does the court in Meyer and Pierce not cite the First Amendment? Why in the Burlington case last week does Harlan not cite the Fifth Amendment? Why?
I don't know about the Burlington case, but I think that it's because the court wants to focus on the due process clause, because right now they're in a time where they're defining what the liberties are and what they are not.
Why not reference the First Amendment? Wouldn't that be easier?
Yes, definitely.
Eric, why? Why don't they cite the First Amendment?
Yeah, I think it would definitely be easier, but that I don't think that would hit on the point of this is I think, like Crystal was starting to say, defining liberty. They're trying to figure out substantive due process and sort of take away, I guess, from what was going on in the progressive era, and so they're trying to, I guess, sort of right the ship, so to speak. If they did that through the First Amendment, they wouldn't.
You're saying it'd be a little more narrow if it was just the First Amendment case.
Right.
Adam, want to take a step?
First Amendment has nothing to do with states' law.
That's right. The First Amendment had, you redeemed yourself. The First Amendment had not been incorporated yet, right? This doctrine of incorporation, where the rights were extended to the states, hadn't happened yet. So the First Amendment didn't apply to the states. It didn't apply. It would later. The Supreme Court would get around to that a couple years later. But at least in the 1920s, when Meyer and Pierce were first decided, the states were not controlled by the Bill of Rights. Slaughterhouse, Cruikshank, and Barron were still good law. Right? So that's why they didn't cite the First Amendment. Now, the crazy part is, if you read later decisions in the 1960s, they try to say, Meyer and Pierce are First Amendment cases. Don't believe it. They weren't. Not even mentioned. But I think Eric's onto another good point that I want to dwell on for a moment. If this was just a free exercise case, right, that you only had the right to read German in a Bible school, Eric, would that apply to a military academy, where you would learn German in a military academy for a bunch of 10-year-olds?
No.
Exactly. So the First Amendment ruling about free exercise wouldn't get you what you needed to do. It wouldn't get you to the end of the road. So you actually needed a ruling saying there are multiple liberty interests, right? There's a liberty of the teacher. There's a liberty of the parent to raise his child. Indeed, there's a liberty of the child himself to learn the language he wants to learn, right? So free exercise and free speech wouldn't get you all the way. It gets you part of the way. But there are all these different liberty interests that are infringed. Now, Martin, why is this not within the police power of the state? Why can't the state decide what language they want the children, the corn, or whatever, the children to be studying?
Well, actually, I think that the court says they can. They can't say that things should be taught in English. However, they can't just limit it to English.
Why not? Why can't they limit it to English? Why is it not in the police power? What if the state doesn't want an entire generation of children coming of age speaking zero English because all they hear is German at home and hear German at school. Why can't the state decide to have a English-speaking population or ban the teaching of a foreign language? Why is it on the police power of the state?
I believe the court said that it was a bit frivolous for how much harm it causes.
What do you mean is a bit frivolous for how much harm it causes? Give me a little bit more.
So there has to be a reason for having each law. That's the whole substantive.
Why does there have to be a reason? Says who? Why can't the government just act arbitrarily and stone people to death because they drew the right to have the box?
Well, I would like to think it's because there's a moral drive behind each of us, and so we don't want to allow such arbitrary laws that can.
So is this law arbitrary? That you throw people in jail for speaking German but not for Greek?
The court said yes.
I'm asking you, is this an arbitrary law? Is this totally unreasonable?
I think it's totally unreasonable.
Well, let's go on to the dissent, right? Bahara, I asked you to read and I emailed this to you, right? I apologize. When you're publishing a book, the stuff you want doesn't always get in there. It's going to be in the third edition. It didn't make it into the supplemental, so I apologize. I sent you a PDF. It was short, like a page and a half. Bahara, what does Holmes say, right? Why does Justice Holmes think this Nebraska law is okay?
Well, he said it's because it's desired for all of the citizens of the United States to speak one language.
Does Holmes think that's a reasonable power of the state to accomplish?
Yeah, and he said it's lawful and it's proper.
So I mean, look, you have Martin saying this is unreasonable, and then you have Holmes saying it's reasonable. Bahara, is Martin any less or more intelligent than Holmes? And actually, I think you're all just as smart, but is one more smart than the other? Can they possibly have different opinions? Is Holmes just an idiot? I mean, what's going on here?
No, but I think overall in this case, like the means to reach the ends doesn't necessarily have to be with the statute. Saying that.
Are you saying the state could promote English speaking absent this criminal statute?
Yes, just like
for example, what could they do?
Well, I mean, they can. Well, if everyone's going to go to school in the United States, they're going to learn English, and then
Not at a private school. That's here. They don't teach English. That was the issue. They're only teaching German.
but they live in America, where everyone's
Not in this neighborhood. That's the state determined that in this neighborhood you have a German school. They speak German at home. German school. Ashley, can the court tell the state of Nebraska you're doing it wrong? You can have promotion of English language, but you can't throw people in jail. Go have a mandatory ESL program at every school, or I don't know, whatever else it happens to be, English second language, right? Why is that not the answer, or is it the answer, right? What power does the court have to tell the Nebraska school board, here's how you run your schools?
What part? So
Why can't Holmes be right? Right?
well, because by saying you can't.
Is Holmes right? Is Holmes, maybe Holmes is right here. Why can't the state decide that they want to eradicate these these German-only schools? Why can't they do that?
Well, because it's made to oppress a specific group of people.
Well, it applies across the board. Everyone wants to speak English. How is it oppressing any? The statute says nothing about this.
Well, but this law was specifically to oppress those people speaking those languages.
But why can't you oppress them? Let them speak English, as Holmes says. Why can't the state decide that people who don't speak English should be oppressed? What's so wrong about that, Holmes says?
What Holmes said?
Holmes says let them speak English. How are they going to speak English? Otherwise, it's not forced. Here's what I'm getting at, all right? We're judging here whether the law is reasonable or not. Martin says it is, Bahar says it is, Holmes says it's not. Or the other way around. They say it's not reasonable, Holmes says it is reasonable. Who's right and who's wrong is a question of judgment, right? The law is quite random. In fact, Holmes actually struck down another law that only forbade German, but allowed the teaching of other languages. That was in the dissent. Right? There was, I think it was in Ohio law or Iowa, some other state. It was Iowa. Those four-letter states. you're welcome too. Who's to say whether a law is reasonable? Holmes's general philosophy is, if it's up for debate, if we can debate whether it's reasonable or not, let the legislature figure it out. And the majority of McReynolds saying, no. And I think this is what Bahar was getting at. It doesn't just have to be reasonable, the law has to make sense, right? It has to actually make sense. And if there's some other way of promoting English language, like maybe having an ESL course or something, do that. So basically the court's saying, hey, you can't have this criminal statute, but do something short of it. Okay? Mark's your hand up?
Yeah, in Holmes' dissent, he talked about how they should have been allowed the opportunity to see if the experiment would work.
Yeah, what's he talking about? Experimentation. What's that about?
Well, it reminded me of O'Connor's dissent from Rake,
Rake.
okay. Where she said that, I'm not saying I would smoke marijuana if I lived in California, but I think it's worth allowing the experiment.
Yeah, so there's this notion, actually it's from William Brandeis, I'm sorry, not William, Louis Brandeis, where he referred to states as the laboratories of democracy. Laboratories of democracy. Very famous phrase in a case called Liebman versus New Ice. The case itself was crazy. The case involved a city that required you to have a license in order to sell ice. It's frozen water, right? And they basically had it that new entrants in the field couldn't sell the ice, right, unless they had a license. And who was responsible for giving licenses? The people already in the field, so they wouldn't let anyone new competitors. So basically, it criminalized competition in the ice field. And Brandeis is saying, wait a minute, we should let the states experiment and see what works best to distribute ice. Okay. Now, you may say that's a silly law, but the people of the state and their elected representatives said, we want this ice law. But at least during the progressive era in Meyer and Pierce and Lochner and Atkins, the court said, no, the court will decide what economic legislation is reasonable, not the people. Everyone see that? So the holding then in Myers is the liberty interest of the teacher, of the parent, of the child prevails. And the state's law criminalizing the teaching of foreign languages is unconstitutional. Holmes in dissent says, no. I think this law is reasonable, I'll defer. The state has this power. But the list of rights McReynolds puts together, it's not quite made up, but it's an articulation of maybe common law principles. So everyone see Myers. All right, Emily, give me Pierce. What were the facts there?
So here in Pierce, we have an act in Oregon that is called the Compulsory Education Act of 1922. And it required parents to send their children who were between the ages of 8 and 16 to public schools in their district.
So what did that mean for private schools?
Enrollment levels went down.
What did things go down? What number did they go down to?
I don't know.
If you're required to send your kids to a public
Zero,
school,
I guess.
0. Yes, thank you. Exactly right. Okay, so this
Substantially affected.
very good. Thank you. So the state criminalized sending children being sent to a public school, a private school. Now, does anyone know why this statute was enacted? Why was the state of Oregon so intent on putting out of business private schools? Anyone want to take a guess?
Taxes?
No, not taxes. Amber?
They didn't have enough enrollment in public schools.
Good guess, but not the right answer.
They just want to put out Catholic.
Bingo. Say it again, please.
They just want to put out Catholic schools.
Yes, ma'am. So at the time, the only private schools were basically Catholic schools and military academies, right? They didn't really have the notion of private schools the way you do today. This was an act supported by the KKK. It was part of a fairly broad anti-Catholic animus. I had mentioned this a few times in class, but even as late as the election of John Kennedy in the 1960s, there was a fear that he'd be an agent of the Pope and that the U.S. would be under siege by a foreign power. So this is nothing new. We've talked about this. So this was an amendment that was put in place to shut down Catholic schools. I like Amber's answer to increase enrollment in public schools. It would certainly have that effect, but that was not the reason why it was. That was not the reason why it was enacted. So, Shivan, in light of Meyer, how does this case shake out?
So, they say the same thing, that by making you send your kids to public school, the parents also don't have that right to choose what education they think is best.
Ah, exactly right. So this case follows very naturally from Meyer, right? Meyer said that parents have the right to direct the upbringing of their children. Children have the right to learn. Teachers have the right to teach. This case is a mirror of that. Who brought the case? Not parents, not students, but the school, the Society of the Sisters, right? This is an order of nuns. And they have the right to teach. Parents have the right to direct the upbringing of their children. And the children have the right to learn. By the way, this case is often cited for the proposition that corporations have constitutional rights. The Society of the Sisters was a corporation. This was brought on behalf of the corporation, not the teacher corporation itself. But Brittany, that doesn't get us all the way. Can the state require, in general, that children under a certain age go to school? In other words, can the state have a compulsory education law, public or private, whatever it is, consistent with this ruling?
Yes.
Okay, tell me why. Did we just say the parents can direct the upbringing of their children? What if the parent decides, I want my son to be a farmer, books and math are not useful for him, he was going to be a farmer. That's it, damn it. Right?
Well, they said that certain studies are plainly essential to good citizenship, and they're not teaching anything that's manifestly bad to the public welfare.
Where did they get that from? Say it again. You gave the right standard. Read it one more time, please. You said exactly right.
That certain studies are plainly essential to good citizenship.
Plainly essential to good citizenship. Says who? Says who?
Well, I know it's citing something, but
Oh,
I knew the Civil Rights Act. I didn't know this one.
No, it's not the Civil Rights Act.
I don't know where it came.
Ellie, the court's doing some sort of balancing here, isn't it? It's saying, well, they can't make you go to a public school, but they can make you go to school, period. Right? Isn't that's basically holding the case? Where do they get that from? Where does that rule come from? They can't make you go to a public school, but they can make you go to school, period. Public or private, your choice.
I'm not sure where it comes from.
Take a guess. Take a guess. What's the court? Well, let me ask the question differently, Kelly. Why is the court putting this limitation there? What if they just said, you know what, children, you can't be forced to go to a public school. Hell, you can't be forced to go to any school. Let the parents put you on a farm at the age of 4. What would a consequence of that sort of decision be? What would the consequence be? Did a lot of states have laws already in the books that said you have to go to school before the age of, say, up to the age of 12 or 14, whatever it happens to be? What if the court said that all education laws, all compulsory education laws are now unconstitutional? What would the consequence of that be? What would happen to those laws, though? Right?
It'd all be contradicting what they just ordered.
It'd be unconstitutional, yeah. So the court recognized the law. If you come out and say that this liberty interest in raising your kids, it's infinite. That would basically invalidate compulsory education laws nationwide. And China, did the court want to do that?
No.
What do they want to do here?
They
Which law in particular are they thinking about here? What laws are at issue here? No, that's the Constitution. What law is under consideration here? Which education law are they considering here? Yeah. So they're only considering the Oregon law, right? The Oregon compulsory education law. They're not considering every law. So what you see here is something the justices always do. They announce a fairly broad principle, and they throw in arbitrary limitations on it. They're saying, well, you have this broad right to raise your children, but don't worry, you still have to send them to school, period. It just has to be public or private. The state can set minimum standards of what's taught. Made up that whole clock. I mean, there's no basis for that other than that they don't want to invalidate, hundreds of compulsory education laws nationwide. Make sense? So Pierce is basically a follow-up to Meyer. The cases follow very naturally. It's not a First Amendment case. The First Amendment's not cited. But it stands for the broad proposition that parents have the right to raise their children. And the state can't impose arbitrary restrictions on that. They can require your kids to go to school, but they can't tell you what school to go to so long as those schools meet certain educational standards.
So are they citing to the Act?
Which Act?
In the passage I read, what are they citing to then?
I don't know what you're talking about.
You asked me what they were citing to, I just wanted to write it in my notes.
There's nothing.
There's nothing,
They made it
they
up.
just kind of made it up?
Yeah.
Okay.
Well, they were citing to Meyer, which in turn made it up.
Okay.
But I mean, Alyssa's mostly right in that they were probably talking about common law rights that were recognized in the Civil Rights Act of 1866, but it's not a clear line. It mentions some stuff that was in the Act, other stuff in the First Amendment, and other stuff that was generally understood.
It was referred to as the Act of 1922, so I think that's the Oregon.
Oh no, that's the Oregon Act they're talking about. But she was asking where they get these rights from. I think that was Brittany's question. Oh, that's okay. Any questions on Meyer or Pierce? These cases are often taught in tandem because they're usually very similar and decided within a couple of years of each other. Questions on Meyer and Pierce? Okay. All right, let's move on. The next case, Buck v. Bell. Have you ever heard of this case before law school? A couple of you. Where'd you read about it?
ConLaw.
College? Same? Okay. Most law students have heard about Dred Scott, Plessy, Brown, the biggies, right, for law school. But very few cases of this magnitude are as unknown. People just don't know about it. I want to give you some background on this case because most law students simply don't know anything about eugenics, which is a good thing. But it was a very significant theory, more than a theory, it was a practice. So this is Carrie Buck, and I have her picture up there. And as you read in the book, she was designated as feeble-minded. She had an illegitimate child and was charged with promiscuity. One of the first things you have to understand about Justice Holmes' majority opinion is it wasn't complete. The reason why she had an illegitimate child is that she was raped by her stepfather. After the stepfather found out she was pregnant, he dropped her off in the mental institution saying she was promiscuous. That was how he dealt with her. This is Carrie and her mother, Emma. Emma, who was Carrie's mother, was also deemed an imbecile. Why? She got an STD. I think it was either syphilis or gonorrhea, but that made her feeble-minded. Not what you thought it meant, did it? This is Dr. Bell, who's actually the superintendent of the Virginia Colony for the Epileptics. Depends how you look at it. Oh, there it is. Oh, there. Yeah, that's it. There it is. Thank you. If I ever pause, it's for you to get a pun, just to give you a couple seconds to think about it. This is the courthouse. I'm serious. It's like Family Guy. So, cut away for a second. This is the courthouse in Amherst County where Buck's case was heard, and this is actually the state colony where Carrie was sterilized. I want to show you this diagram. One of the most memorable lines in the opinion is 3 generations of imbeciles are enough. Did you all flag that when you were reading your notes? Mm-hmm. Do you know how you get to 3 generations of imbeciles? It was a family tree. This was actually a piece of evidence in the record. I'm not joking. This graphic will be in the 3rd edition of your book, but you have it up here for now. And it says here, the most immediate blood kin of Carrie Buck. So, it's hard to see, but there's 3 circles here, right? There's circle 1, circle 2, and circle 3. So, this little finger here, that's Carrie Buck. And inside the circle is an F, the letter F. F stands for feeble-minded. So why was Carrie Buck feeble-minded? Again, she was raped, she became pregnant, and they dumped her in a mental colony. That was her feeble-minded. She was actually a pretty good student. She was able to read and write. Okay. The mother of Carrie was Emma. And Emma was deemed feeble-minded because she had either gonorrhea or syphilis. I'm drawing a blank, but some sort of STD. Then we get to the third generation of feeble-minded, Vivian. At the time, Vivian was about 6 months old. And they determined that the 6-month-old was feeble-minded. Now, I'll show you a picture of her. Very cute baby. Where is it? Here's Vivian around 6 months old. How do you determine if a 6-month-old is an imbecile? They can't read, they can't speak, they basically just poop and cry, right? That's what do babies do. They did a test. I swear to God, this is the actual test, where they took a coin, shiny coin, and they put it in front of the baby's face, and they checked to see whether the baby's eyes were tracking the coin.
The guy with the wonky eye did that?
Well done. Yes. Actually, I don't know if he administered the test. I think a different guy administered the test, but
So what if you're not? Then you're feeble-minded as well?
the point I'm trying to convey to you is that this is all bullshit, right? I think Mark's good job. I think Mark's comment is basically right on point. This was basically all ruse. None of these people were actually feeble-minded in the sense that they were stupid or mentally handicapped. They weren't. They were human beings, normal. Carrie Buck, I think, made it through the 9th or 10th grade. She could read and write. Her mother was a working person. By the way, the Vivian, the child that they said was feeble-minded, I actually found a copy of her report card. She got mostly B's, right? She was a decent student. She died at the age of 8 from some sort of intestinal disease, but she was by no measure feeble-minded. So that was the basis on which they were deemed feeble-minded. So the word feeble-minded does not mean what you think it meant, at least back then. And the reason why was because of eugenics. Now, what is eugenics? It's probably a word which maybe some of you have never seen before. It's the idea of using science to remove undesirable traits from the gene pool and to promote desirable traits. And you say, wait a minute, Josh, wasn't that the Nazi stuff? Well, it's true. The Nazis perfected eugenics. They stole it from us. It was basically developed in America, in institutions. Harvard, Yale, Chicago, right? The leading institutions in the country had departments on eugenics. Theodore Roosevelt, William Howard Taft, Woodrow Wilson, Coolidge, right? Even Helen Keller, all backed eugenics. And the idea was this. They didn't have the science to modify genes back then. So the way to prevent bad genes from going to the gene pool was to make sure those people did not reproduce. And contraception didn't really exist back then, at least in its current form. So the best they could come up with was sterilization. Tubal ligation, if you want to be precise, which is basically removing basically cutting the tubes, right? And also vasectomies for men. This was both men and women. And the idea was these imbeciles could not be allowed in public unless they were sterilized, because if they were in public, they would just go and breed, and they would just repopulate their imbecilic traits. So the only way they could be released was by sterilizing them. And I want you to think about this just for 1 minute. The government argued that we have the power to keep these people in the colonies, right, these homes. And it's expensive to keep them in the homes, right? If they're in their homes, we can keep an eye on them, they can't reproduce. But to save money, we want to let them out. But we can't let them out with their tubes untied. So we'll let them out with a sterilization procedure. That is what this case was about. They said we have the greater power to lock them up for life to ensure that they don't reproduce and corrupt our gene pool. So we need the far lesser power to do a little snip snip and let them live their lives as a normal person in any way they want. That was the power at issue here. And this is the an advertisement I found from the 1920s, and it said, "Eugenics is a self-direction of human nature. this is a little bit harder to read, but that some people are born to be a burden on the rest. Learn about heredity. You can help to correct these conditions. This was a very prominent movement that appealed to the highest echelons of American society of how to improve our society. And in fact, I think I have it down here somewhere. No, that's it. The Nazis basically gave an award in 1936, basically, even World War II, to the scientists at issue in Virginia. Virginia was one of the leading states that was promoting this this doctrine. Okay. All right. So, any questions in the background? Any questions on that in the background? Yes,
That's
Kevin.
still common practice today?
Oh, I'm so glad you asked that. Kind of. So, because of Buck v. Bell, which basically was a test case and gave a green light to eugenics, I think 30-something states enacted compulsory sterilization laws. And these laws were on the books in the 1960s and sometimes 1970s. In fact, I had a student from Puerto Rico a couple of years ago, and she said an aunt or something of hers had it even later than that. So even if the statutes were reversed, they were still done. Where this comes up, though, and there was actually a case involving a prisoner, I think maybe 10 years ago, which involved Buck v. Bell, where the prison basically had a woman who had a number of children. I think she was involved in crime, whatever, and they basically coerced her into getting sterilization. They didn't exactly describe, perhaps as honestly as they should have, what they were doing. And she sued for damages, and she lost because they said the state has this power in certain circumstances to actually sterilize a person. One note, when you read the case Roe v. Wade, which is the big abortion case, this is not in your book, which drives me batty. You'll read the 3rd edition. By the way, it's funny. My co-author complains with students about stuff I added, and I complain about stuff he removed, so it goes back and forth. But there's a sentence in Roe v. Wade that's saying, oh, a woman's right to her body is not unlimited. See Buck v. Bell, right? That the state still has a superior interest in your body, it's not unlimited. So this case still actually has validity. It's never been overturned. Never, won't be cited, I doubt. But that Court of Appeals decision from the 8th Circuit is cited. It gets worse. It gets worse. So this case is about substantive due process, right? Substantive due process, which we think of a liberty interest. But what about process itself? Did Carrie Buck actually get a fair process? And the answer is, oh my God, no. So let me walk you through these facts. Carrie Buck's lawyer, here, not crazy eyes, right? But having 2 New Yorkers in the same class is dangerous, I think. Having Carrie Buck had a lawyer during these proceedings. Her lawyer worked for the colony. What? Her lawyer worked for the group that was trying to sterilize her. Her lawyer provided no real defense. He called 0 witnesses, and he didn't challenge any of the evidence against his client. The purpose of this case was to get a test case up to the Supreme Court. They wanted the Supreme Court to bless this, and they chose Carrie because of the 3-generation bit. They said, look, we can prove that imbecility is genetic. You have the grandma, you have the mom, you have the daughter, right? We can prove 3 generations. That's what they were trying to show. That by cutting off Carrie, she stops this seed from going forward. Like, that's what they were trying to do. So Dr. Laughlin, who was one of the lead evidence, didn't even appear at the trial. He sent a written deposition. He never met anyone in Carrie Buck's family. He basically just repeated what he heard, that they were shiftless, ignorant, and worthless class of antisocial whites of the South. That was how he described them. He focused on Emma Buck's syphilis. Carrie apparently sent some flirtatious notes to schoolboys. They made her promiscuous. That was like texting back then, right? Or worse, I suppose. Thank God they didn't have Snapchat back then. That would have been much worse. And they said that the child, Vivian, was below average intelligence. She was 6 months old. Carrie Bach also, it's not clear if she even knew what was going on. They may have even lied to her about what surgery she was getting. I read one case where they told a woman that she was having some problems with her hips, and they needed to do surgery to alleviate pressure on her hips. So there's evidence that she didn't even, eventually she found out, but she may not even known throughout the process what was going on. And there was one quote which is attributed to her saying, "They done me wrong, they done us all wrong." Now, none of those facts that I just gave you were in the reading, if you noticed. Justice Holmes' opinion was rather was rather thrifty, right? There just wasn't much there. All right. So questions. Yeah, Mark.
Plato's statement in Meyer seems out of place, but would be appropriate here, where he said that the offspring of the inferior or of the better, when they chance be deformed, will be put away in some mysterious unknown place, as they should be. I mean, isn't that basically Plato's version of what was referred to as eugenics?
Well, wasn't Plato cited in McReynolds' opinion in Meyer?
Right, and
Yeah.
I don't know how it fits.
Yeah, it's a weird fit. I never get that when I read that part because it doesn't fit at all. Well, we'll get to the we'll get to the Holmes opinion in a minute, but I think Mark's point is worth dwelling on. This case seems entirely at odds with Meyer and Pierce, right? That you have the right to direct the upbringing of your children, family, liberty, but here they can cut your tubes if like you have a legitimate child, right? And if you notice, there was no dissent written in this case. Justice Butler dissented, but without a written opinion, which was a fairly common practice at the time. So one of the other reasons why this case is so infamous is that there's no contrary opinion. You know, you read Harlan, right, in Plessy. You read Harlan in civil rights cases. You read Justice Field in Dred Scott. I'm sorry, Justice, not Field, yeah, Field in Dred Scott, right? You read, no, it wasn't Field. It was Curtis and the other one, I'm drawing a blank. But you read the dissents in Dred Scott. These cases, right? These cases represent dissents. You see the other position, but here, Holmes's assertions go unchallenged, and in fact, his recitation of the facts is utterly lacking. So I've given you all the facts. I don't remember where I'm up to. Jason, you have a question?
Yeah, I
Please.
just one question. So the opinion makes it seem as if it could translate to any prisoner or anyone who's in a system, if that system has its own boards or procedures, they get their due process through those procedures. So it talks about how...
Yeah, all they talk about is process. They're big on process, right?
So I guess the question is, that could that relate, because in this instance, they're talking about feeble-minded, which I don't think it matters what definition you use. I don't necessarily agree with the opinion, regardless of what feeble-minded means, but it seems like you could say that a prisoner in jail, if there's a parole board, could make a decision, you're here for 40 years more, and they got due process because it was part of the system that's in there, without him ever going to trial again, or being a judge or jury or anything.
Well, let me answer your question a different way. Does Holmes even agree that there's a liberty interest in not having your fallopian tubes cut? Does he even address such a thing? In other words, let's say the process was fair, right? Let's say that Carrie Buck had a real lawyer and had a real trial, and at the end of the trial, the judge said, yeah, she's feeble-minded, she's promiscuous, snitch. To Holmes, is there a problem with that? That's right. The important point about this case is they recognize zero liberty interest in bodily integrity, right? There is no liberty interest in not having your tubes cut. Adam.
It kind of reminds me of in the 1960s and 70s, especially in mental institutions where they were, lobotomizing, electrocuting people, or whatever ends that they, thought they would actually get to. And I can't help but feel like this was a basis for the institutions to treat people under, however they wanted, because, the powers that be thought that was somehow beneficial to society.
I think I think what the court recognizes here is that there simply wasn't any sort of right to protect it all. And the police power was so broad, and the need was so compelling to eradicate the gene pool of these people, that they were willing to let this go.
That we just don't like this chunk of society, so we're gonna turn a blind eye.
Yeah. Yeah. Yes, Jason.
So there's been a resurgence in modern eugenics, which is a little different, but now they talk about, they actually have the ability to change DNA, and so there's been instances where they talk about doing things before a child's born to prevent an illness or whatnot by searching. And in fact, I think the UN said that modern eugenics is actually different, should be looked at differently than old eugenics. But under a case like this, would there be precedent for a doctor to say, hey, I'm going to do a procedure on your unborn child? Otherwise,
well, the question is what a doctor can do. Here, the law is mandated by the government, right? If a private individual decides to experiment on a fetus, that's a crime. That's called attempted murder or something, right? But here, the government's mandating you get the procedure after.
but could the government here mandate that if we can do these tests and know? I mean, there's a lot of tests you could do now to know the health of a child.
Oh, I see what you're saying. Could the state, if the state says, we require you to perform a test for Down syndrome on an unborn child, and if the child has Down syndrome, you're required to terminate it. So is that what
Something
you're
like
getting?
that, yeah.
Because having a person with Down syndrome in the population is bad for the society. Sounds like a good final exam question, but I mean, what's your thinking? I mean, I want to take a stab. I won't call anyone for this one. Under Bach, would there be anything wrong with that? No? What do you think, Jerry?
Under Bach, no. That is essentially what they're doing. What I got from the holding was basically if there's a greater need for social welfare, that there's no, the argument was substantive law, and it wasn't a procedure, and so the issue was not procedure. So answering Jason's question, that the procedure of going about eliminating children because of that wouldn't be an issue as long as the greater premise was.
Very good. Very good. Yeah, I think that's right. You want to add something else? Yeah, Carla.
What was the question? I'm sorry.
Oh, it's too much of a wind-up. I can't do it again. Anyone else want to add? The question is about a mandatory law about terminating a child with Down syndrome.
Okay.
Go for it. Yeah.
My brother, one of his children, when they were pregnant with one of his children, they were told that the baby was going to be born with Down syndrome, and the doctors were recommending abortion. They decided not to, and the baby was born and perfectly fine. No Down syndrome. Well,
that's the other issue, right? What happens? I mean, perhaps that's an extreme example, but what happens if they're wrong about if a child having Downs, or they're wrong about carrying Bach? Governments make mistakes, right? Doctors make errors. It's not possible. Okay?
But wouldn't they have to go to court again and say?
But they got all the due process they were due. They had a hearing. The judge said, I agree with science, and that's it. Now let me give you one other factoid, which is relevant to this case. The Sterilization Act here was called the Genic Sterilization Act, passed in 1924. It's called the Racial Integrity Act. The Racial Integrity Act, huh? What was one of the other provisions of this law? It criminalized interracial marriage. You'll study a case in a couple weeks called Loving versus Virginia, which basically involved an interracial couple in Virginia. The same law, the very same act that criminalized interracial marriage, also required the eugenics, right? The sterilization. They're from the same stock, if you will, right? The idea that you have to keep the gene pool pure. And that was done by A, preventing races from marrying and reproducing, and B, sterilizing those who had imbecilic traits. So these were part of the same eugenic movements from the 1920s. So it gives you a sense of where this comes from. All right. So the facts of Bach, I think we've already covered most of them. But basically, after Mr. Blinky, right, determined that you were an imbecile, he actually wasn't the original guy. He was substituted, Mr. One-Eye, right? He actually came in later. By the way, I want to put a picture from the book, but we couldn't find a copy that had copyright protection in it. So we couldn't get a copy from the book. Sorry about that. So after the colony determined, right, after the colony determined that a person was an imbecile, they had a hearing, they had a trial, but there was no meaningful process, right? Because what was the standard? Is a person an imbecile? And how's a person an imbecile? If they meet any standard there is. So there was a trial, there was a hearing, but this was not much more, this was no less arbitrary than lottery, right? The same standard by which people were stoned in the lottery, picking a number of a hat, that had about as much science as what happened to Carrie Bach. But ultimately the court upheld the sterilization because they find she had all the process that she was due. And Justice Holmes' opinion, which is very difficult to read, has these lines that are very mean. And he actually wrote them deliberately. He said he enjoyed writing his opinion very much. This was an opinion he enjoyed writing. Because I think he subscribed to these ideas. I think he sincerely did. You know, for example, it is better for all the world if instead of waiting to execute degenerate offspring for crime, or to let them starve for their imbecility, society can prevent those who are manifestly unjust from continuing their kind. What's he saying there? It's better to sterilize people now than to have to incarcerate their children later. Mark?
That's actually interesting. I thought of this before, is that there are statistics that show that crime in inner cities have gone down since Roe v. Wade.
Yeah, I'll pass on that one for now.
But they're quite parallel, those two concepts.
Yeah, that was in Freakonomics. I know the numbers. I'll pass on that for now. Okay. Other lines that Holmes discusses, right? I mentioned that 3 generations of imbeciles are enough. And this one's good. The principle that sustains compulsory vaccination is broad enough to cover the cutting of the fallopian tubes. Who am I up to next? Who's next? Oh, I think she's next. Sorry, I'll come down to you for a bit. Can the government have a compulsory vaccination where they make you get vaccines? Is that constitutional? It's okay. That's fine. Good. Yeah. Why not? Why can't the government make you have a vaccine? What's the problem? You know, if one person doesn't have a vaccine, it's no big deal. But if the entire population isn't vaccinated, you have a smallpox outbreak, the entire city will die. You need herd mentality. You know, a certain percentage of your community to have this vaccine. Can the government not make you take a vaccination? What does Holmes say about this?
Under what he wrote here, I mean, in his eyes, probably, yeah, you could.
Yeah, so Jay, I'll come back to you. If the government can make you get a vaccination, why can't they make you get sterilized? What's the difference? They're putting a little needle in your arm, they're doing a little snip, you're fine after that. If there's an intrusion on your body, why is one allowed and one not?
According to Holmes?
Yeah. Right, why is there a difference? Or even according to, what's the difference there?
Well, there is no difference.
She's right.
Holmes didn't differentiate the two at all, actually.
Yeah. And they even use a bigger example, right? Jay, can the government make you go to war?
Yeah.
Can they draft you? And you can die there, can't you? So the government can make you go and take a bullet from a German soldier. Why can't they just in far lesser, just sterilize you?
There's absolutely nothing wrong with that.
Right, so here's the deal, right? The government often calls on people to do various things that are not life supportive, let's say, right? They can send you off to a violent war where you're probably shot down. They can give you a vaccine, which this is not Jenny McCarthy stuff. These were actually dangerous vaccines that could kill you, right? Back then, in the 1900s, the smallpox vaccine could kill you. They were basically a weakened strain of the virus, which wasn't very precise. Okay? But if the government can do all those things, why can't they just sterilize people? So I'm going to leave it there. It's a case which we'll come back to when we discuss Roe and other cases. But it's still good law. It's still on the books. And the reasoning here is, as alluded to by Mark's question, is still somewhat accepted by society. It is. The thinking behind the eugenics cases are not gone. It still exists in many quarters. All right, so any other questions on Bach? Yeah, Brendan.
Is it considered anti-canon? I guess not.
I would, but it's still cited. I consider it, but I told you it was cited about 10 years ago in a case involving somewhere in Missouri, I think, somewhere in the 8th Circuit. That was still cited. By the way, another place that cited Roe v. Wade was the Nuremberg trials. So when the Nazis were on trial for crimes against humanity, their lawyer actually read from Buck v. Bell, saying, look, it's not just us, it's the U.S. Supreme Court as well that endorsed this. That we're not that bad. How could we be crimes against nature if the U.S. Supreme Court had sanctioned this years earlier? Yeah. I put the clip up there. I don't have time to play it now, but you can watch it later. It's like a 2 or 3 minute clip. All right. So from very sad eugenics story, let's find something a little bit easier, which is bread and milk. I love this picture. I can't find a copy of this picture with a copyright to put in the book. It drives me nuts. I don't know where I found it. I have no idea. But I can't find, it's probably not legal here, but I can't find a copy that the publisher let me tell you. It drives me nuts. Such a good picture of a little bottle of milk, a little loaf of bread. Jack, what did Mr. Nebbia do that got him in trouble?
Oh, he set his price of milk outside of the range that was appropriate.
Now, he did it in a very smart way. Did he actually change the price of milk?
What was the incentive that he had?
Yeah, what was the deal?
Yeah, I'm not totally sure, but if they get a free loaf of bread.
Yeah. So, right, he couldn't lower the price of milk, right? But he said, I'll tell you what, if you buy 2 bottles of milk, I'll give you a free loaf of bread. And the consequence of that was basically a deal. You were reducing the cost of the loaf of bread. Everyone see that, right? Everyone understand what's going on here. He couldn't change the price of the milk, but he said, I'll tell you what, if you buy 2 bottles of milk, I'll give you a loaf of bread for free. And that basically makes it cheaper because the bread's free. The Supreme Court considered whether he could be convicted of a crime. Right? Lacey, what happened here?
The court, well, he tried to say that the statute and the order was covered under the Equal Protection Clause, the Due Process Clause, but the court said it was not.
Yeah. So Nebbia said that this is like Lochner, right? That this is a violation of my liberty interest under the Due Process Clause. The Supreme Court disagreed. They voted against him. And they said, well, the state's police power allows for this regulation. And if you notice, they discuss this sort of presumption in favor of the validity, right? This case begins to signal that the court's retreating from Lochner. That instead of giving this strict scrutiny of the state legislation, they're beginning to become a little bit more deferential, right? Now, Rachel, why does New York need a milk law, right? What's the purpose of this milk law? What rational end could it possibly achieve? Why does New York need to regulate the price of milk? Why can't the free market dictate the price?
It should, but their problem was that this is right after the Great Depression, and some of the milk farmers were having problems selling milk. So this is basically the government's way of subsidizing the milk farmers.
That's a very good answer. Right, so this is basically a giveaway to the milk industry. By setting the price of milk, they're making it that people have to pay more out of pocket for milk, right? That's what the statute. This was a kickback to the milk industry. Now, Rachel, ask you the follow-up. Is there anything wrong with the government passing a law to subsidize the milk industry? Is there anything wrong with that? Is there anything problematic about that sort of law?
Yes.
Why?
Well, it leads to lawsuits like this.
No, this wasn't a lawsuit. Nebbia was thrown in jail. This was a criminal offense.
Criminal process.
But what's wrong with the government under its police power trying to subsidize an industry that's been hard hit. The poor dairy farmers, they wake up at the crack of dawn, they're milking cows and everything else, I don't know what's happening. Whatever they do, they're doing that at a really early hour. Right? What's wrong with that?
So it limits the consumer's options too, and their ability to go and shop for other options.
Isn't it part of the state's police power to regulate and help certain industries? Why can't they just help the milk industry? Who cares if they're hurting the bread growers or customers? Who cares? You don't grow bread, do you?
No.
Bake. I have no idea.
Well, they said it was management. It was price fixing and management, and a person can still control their own affairs.
Right. So what I think Rachel and I are getting at here, no, you do not grow bread, I know what I'm talking about, is this. If bread rises, I suppose. Is this. The police power is very broad. And even if the purpose of the law is to help one group and punish another, that will pass constitutional muster. Right? Even if the law is designed to help one group and help, because you're basically helping the dairy farmers and you're hurting the bakers, and the bakers don't get that same kickback, right? That's within the police power. And the courts won't intervene. I mean, go read McReynolds' dissent. He's like, this law is arbitrary, right? Who's to say how much a gallon of milk costs? Let the market set the price. If Leo Nebbia thinks he can get by selling milk at a discount to compete against the bigger grocery stores, let him do it. But that is not the holding here. Okay? So Nebbia, you're beginning to see the court drift away from Lochner and towards what happened in West Coast Hotel v. Parrish. All right, everyone with me so far? Mark, is your hand up?
No.
Okay. Go with me so far. All right, Eric. Give me the facts in West Coast Hotel. This is the West Coast Hotel in Wenatchee, Washington. This was not a contemporary picture, it's a black one, so it looks old, but it's just a filter. But that's what it looks like now.
So I do just want to point out, I will give you the facts, but you're jumping to me again instead of skipping back to over there.
Oh, you're right. Thank you. I never remember.
You've done that 2 classes in a row. I'm just establishing my constitutional right.
You have no rights in this class. I'll respect your privilege. All right, you're up.
Remember the minimum wage law passed for women?
Okay.
And they're questioning whether fixing the minimum wage law for women might have been.
Good. So, where have we discussed minimum wage laws for women before? We've done this before in a couple of cases, right? Haven't we? We've done this at least 2 cases I can think of.
I think it was Bradwell.
Well, no, Bradwell is about the female lawyers. You're on the right track. What cases have we discussed? Good review from the midterm, right? What cases have we discussed involve the minimum wage for women? Give me one of them. One that we did last class, I think. No. That was the zoning case. Andre?
Was it Atkins v. Children's Hospital?
Atkins v. Children's Hospital DC, I think it was 1926, right? Andre, what was the holding in Atkins?
That it
Yeah, Jim?
That if women they were equal, then they should be equal. They should be able to fight for their own wage.
Did the court uphold or strike down the minimum wage law for
minimum
women?
wage.
Okay, good. So in Atkins, 1926, the court struck down the minimum wage law for women, right? That's not the only case we did. Elizabeth, remember the other case we did? Muller v. Oregon. What was the holding in Muller? Very good.
That you could have, maximum hours for women based on their stature or being sex class.
Yeah. So here, Muller upheld the maximum hour law for women. Atkins then struck down a minimum wage law for women. So we have these precedents that go back and forth, right? Are women equal? Can they be treated the same? So Elizabeth, give it to us. What's the bottom line in West Coast Hotel? What does the court do to Atkins? Overruled Atkins. And we go back to Muller, don't we? So now, Zach, why does the court overrule Atkins? What's the reasoning here?
Was protecting
It's women, in this case, we're kind of people that don't have the same bargaining powers as boys. It's protecting like the general welfare and safety, health of the employees.
Very good, right? So what the court basically says is the state's police power, right? The state's police power is very broad. The state's police power is very broad. And we are not going to be in the business of using the due process clause to supervise the state's police power. If the state determines that the Constitution protects this liberty interest, or I'm sorry, if the state determines that women need an extra boost in the marketplace, they can do so, right? The state can do so. And they expressly overrule Atkins. Okay? They go back to Muller. They say as long as this law is not arbitrary and capricious, that's the end of the matter. That's all they have to decide. They're right. Even if the wisdom of the policy is debatable and its effects uncertain, it's the judgment for the legislature to make. And this is the question we had before, right? Should kids learn only English? Should they not? Is this a debate to be had? What the signal was in West Coast Hotel is we are not going to be deciding these debates anymore. The courts will be hands off. If the legislature wants to have this regime in place, they can do it. If the legislature wants to help people through a higher wage, they can do it. And therefore Atkins is overruled. Right? Everyone with me so far? Anthony, what does Justice Sutherland say in dissent?
Basically not to overrule Atkins.
Yeah.
To follow precedent.
Why? Why does he think that Atkins is worth saving? So it's a counterintuitive opinion because you're like, yay, go majority. It's like, oh, yay, go dissent, right? What's his argument dissent there?
Because they all thought it was properly decided. So.
Does the law afford a reason why men should be treated differently than women according to the dissent?
I don't think so.
Why not? What does Sutherland say here?
The words of the Constitution.
Case, you want to take it?
Just that the meaning of the Constitution doesn't change.
Yeah. His notion is that the Constitution doesn't have a variable meaning, as a fixed meaning. And regardless of the economic conditions of the day, depression or otherwise, states can't violate these sorts of rights because men and women have equal bargaining powers. Right? But that was just a dissent. Now, why was this case 5-4? Let me give you a little bit of history here. This case was decided in 1937. It was argued in 1936. So this is that magical year we've talked about, 36-37, right? The conventional story, which is not true, but the conventional story you may have heard, or not, is that the 5-4 decision here flipped. That Justice Owen Roberts, who originally voted to uphold to strike down the minimum wage law in Atkins, changed his vote and voted to uphold the law. Why? The story goes because of Roosevelt's court packing plan, that because of FDR, Justice Owen Roberts said, I don't want to have this fight with the president, I'm going to support this law. It's not true. According to the docket books, the vote was basically cast before the court packing plan came around. So this was known. Also, most people expected the court packing plan to fail. So this is not a case where Roosevelt intimidated Justice Roberts changing his mind. But this does represent a shift in the court. And after this case, Roberts, who had been somewhat conservative, went along with New Deal legislation. He went along with progressive legislation. And as a result, the court said, we are getting out of the business of policing these matters. So any question on West Coast Hotel? Not a difficult case doctrinally, just saying we're overruling Atkins, courts will not get involved.
You just said that they did not overrule Atkins?
They did.
Okay.
Did they say the wrong thing?
Okay.
I may have. I do this weird thing where I invert things in my head, where I say it is and it's not, and grow bread and stuff. So if I do that, correct me. Growing bread, what was I thinking? I was thinking of growing wheat and whatever else. I often invert things in my head. It's an annoying trait. All right, so any questions on West Coast of L.B. Parrish? The next case, though, is the biggie. The next case, though, is the important one. And it's called United States v. Carolene Products. And this is a case that I spent a long time on. And it was basically random. I have you may know, a collection of knickknacks. So years ago, I bought a case of Milnot, which is actually the milk product. I never actually tried it. I don't even care what it tastes like. It's like with the barbecue sauce. I've never even opened the bottle. But I have an entire case of this stuff, which is basically filled milk. And then I started buying on eBay. I have all these alerts on eBay. Carolene product cookbooks, the 1930s, in very good condition. This one's 1937, 1940 something, I think. So all these Carolene product cookbooks, I've been blogging about this. And then, out of the blue, I get an email from this woman, Donna Sapp. She says, I am the granddaughter of Charles Hauser, the president of Carolene Products Corporation. I'm like, no way. So, I emailed back and forth a few times. Then she calls me. Talking on the phone for a bit. And she's like, yeah, my grandfather had these Supreme Court cases. And then I'm like, oh, yeah, no, I know about the Supreme Court case. No. Cases. What do you mean cases? Everyone knows about the first Carolene Products, but barely no one knew about the second one. I got that. And then she said, oh, yeah, and by the way, decades later, after the Supreme Court ruled against my grandpa, a federal judge in Illinois struck down the filled milk act. I'm like, what are you insane? It never happened. She's like, trust me, it did. And I researched and she was right. So as best as I can tell, I'm the first person who actually connected it to it. Barnett stole from me without crediting me, but now I'm in the book, so it's fine. But this is an absolutely, it's true. He stole a lot of stuff from me, but it's fine. I'm in the book now. It's really fun, though. He complains to students, I do the same to mine. It's actually delicious, right? But this is a very significant case because of the rule of establishment. I want to give you the facts first. The facts here are amazing. So Charles, I've asked Donna to give me a better picture. She hasn't done it yet. This is Charles Hauser. The best picture I have. It's really small. You can zoom in later. Here. Yeah, you can barely zoom in. Whatever. That's him. He was a businessman. And his business was making filled milk. Now, what is filled milk? You take dairy milk, which I guess you grow from a cow, right? And you remove, there it is, you remove the dairy and you replace the dairy with vegetable oil. And because you add vegetable oil, so you can put in a can. It's not that gross, actually. It's good, it's sweet. It's good milk. You never had any? It's good, try some later.
Isn't that like a McDonald's milkshake?
Basically. So you basically take out the dairy and you replace it with vegetable oil. You replace the dairy with the vegetable oil. As a consequence, you can put it in a can and it does not require refrigeration. Now, if you were a poor person in the 1930s, this was amazing. Get all your vitamins, get your nutrients, and you don't need to have refrigeration. Because people just didn't have power back then. Now, what do you think didn't like filled milk? The people who grow milk, right? Yeah, the dairy farmers, right? They did not like, I have way too much fun here. They did not like these products because it put a dent in their business. In fact, one of the biggest enemies of the dairy farmers was margarine. Why margarine? You don't have to refrigerate it. It lasts forever, right? You can just put it in a box, it lasts forever in margarine. There were actually laws that said you had to dye margarine pink. So it would be so ugly no one would put it on their bread. They had similar traits against filled milk where they made it a crime to make it. The actual act of putting the vegetable oil into the milk in a number of states was a crime. But an issue here is not the federal ban. I'm sorry, it's not the state ban. The issue is the federal ban. And Congress enacted a federal ban on shipping filled milk in interstate commerce, right? Now this wasn't like Wicker v. Filbert where you're growing wheat with substantial effect. This was literally shipping these cans across state lines. Okay? So Charles Hauser, who was the head of Carolene Products, challenged this law in court. It was actually a criminal case. And the Supreme Court upheld the law saying, of course, Congress can regulate the transportation of filled milk. This is commerce. Congress decided to eliminate this unhealthy product from the marketplace. That was only the beginning of the case. A couple years later, Hauser and his lawyers said, you know what, this law is vulnerable to challenge. We're going to challenge this again. And the family story, which I don't think is true, but this is the family story, is that Charles Hauser personally drove a milk truck across the Virginia state line. Now, why did they choose Virginia? Hauser's lawyers told him that Virginia had good courts and it'll be favorable to him. In fact, Hauser told the government in advance, hey, you guys, I'm going to drive a milk truck across this border. You think it worked out for him? No, it did not. This is a true story, I swear. After he drove across this border, this milk truck, he was arrested. The judge denied bail. The marshal couldn't put the guy in prison, so he had him as a house guest for the night, right? But eventually, Hauser was convicted. And his case was appealed to the Supreme Court a second time. And he challenged the constitutionality of the law again. The Supreme Court ruled against him 9-0. But then the crazy part happens. This part, I think I'm the first person to actually report on this. Shortly after he got sentenced, his lawyers submitted a petition for a pardon to President Roosevelt. And about a month later, as he was getting ready to board to prison, FDR gave him a pardon. Can you imagine that? This guy had challenged the Roosevelt administration twice in the Supreme Court. Twice lost, unanimously. And then FDR gives the guy a pardon. The crazier part is Roosevelt died like a month or two later. So this, I think, was one of his last pardons. I got to track it down one day. I think this was one of his last pardons issued. But the funny part is, and this is the hilarious part, where was the pardon hanging for all these years? In the bathroom of the social club where he lived. He was a staunch Republican, did not like Roosevelt very much, but he, to be sure he thought of the conviction. But he put on this pardon on the wall. So this is the actual copy of the pardon. It will be in the next edition of the book. But it's an absolutely amazing tale. But then it gets better. I swear, it gets better. So even after he'd lost 2 cases at the Supreme Court, he wasn't done. So what did he do? He built a factory on the Missouri-Oklahoma border. Right? See this little dotted line right there? The border went down the middle of the factory. He had cargo doors on both sides of the factory. And there was a brass strip down the middle of the factory. As soon as the filled milk was created, nothing ever crossed the strip. So you had the Missouri side of the factory, and you had the Oklahoma side of the factory. This guy, right? Genius, right? These guys. His daughter told me this story, which I swear is true. Whenever he would go to a plane, to board a plane, he would never board, right? He said, Grandpa, get in the plane. They're calling you in. He's like, no. Wait for it. And they say, would Charles Hauser please board? It's like, see, free advertising. Because they announce his name. This was this guy. This is before TSA, right? This is before TSA. But this guy, so for decades, he'd ran his business out of these 2 borderline factories. What was a borderline factory? And eventually in 1972, the case against your chapter, Milnot v. Richardson, the Supreme Court, or actually a district court, struck down the filled milk law, saying it was totally irrational. And again, this stuff is healthier than real milk, right? It doesn't have cholesterol. The bad stuff in milk is the cholesterol. This is actually skim, right? It's actually healthier for you.
The oil is cholesterol.
What?
The oil.
Less. It's bad. It's better for you.
Oh my gosh. Vegetable oil is not good fat.
In the 1970s, perhaps it was. But the point is, in many respects, this has less bad stuff than the actual milk. Ashley, you might disagree. But the court struck it down. Fine. Disagree with the judge. But the point is, this law eventually failed. Now, that's all postscript. But the reason why this case is important is not because of filled milk. It's actually secondary. It's for the famous footnote 4 of Carolene product. I want to read you through it. I have it up here. I want to read it to you. It says, there may be a narrower scope for operation for the presumption of constitutionality when legislation appears on its face to be within a specific provision of the Constitution, such as the first 10 amendments, which are deemed equally specific when held to be embraced within the 14th Amendment. Who am I up to? Carlo, you next? Carlo, what does that mean, that first paragraph? A narrower scope for the operation of a presumption of constitutionality. What are they getting at there? What are they talking about there?
That the law laws created by the legislators should be on, I guess, at their face.
What's presumption of constitutionality? What does that mean?
It's a presumption that that the Supreme Court, I guess, gives the legislators that when they've deliberated on creating a certain law, that they've done so with in mind not wanting to violate.
Yeah, this idea of a presumption of constitutionality is that when the legislator acts, you start off with the presumption that they're acting lawfully, right? You don't just presume they're screwing up, you presume they're acting lawfully. So in this first paragraph, Carlos, what sort of laws are afforded, or I'm sorry, what sort of laws are not afforded a presumption of constitutionality? In other words, when is this operation narrowed? When do you narrow that presumption? What sort of laws?
Anything that's...
What does it say?
Such as those of the first 10 amendments, which are deemed equally specific, when held to be embraced within the 14th.
What about the first 10 amendments? When do we apply this narrow scope of presumption of constitutionality? Read it.
When it's outside of the 10 amendments.
What are you looking at? What do courts look at when they're considering this? It says it right there.
In the first paragraph?
Read it. Read it. Just read it out loud.
There may be narrow scope for operation of the presumption of constitutionality when legislation.
Stop. What are courts looking at?
Legislation.
Bingo. And what about that legislation takes it outside the presumption of constitutionality?
What takes it outside?
Yes. What about that legislation removes it from the presumption of constitutionality? It says it right there. Keep reading.
Appears on its face value to be within specific prohibition of the Constitution, such as those of the first 10 amendments.
What does that mean?
Well, when it's viewed on its face.
When what's viewed on its face?
The legislation is viewed on its face to contradict.
Very good.
Amendments.
So what's that saying? If any statute on its face violates the first 10 amendments, you don't give the full presumption of constitutionality. You narrow it. You restrict the scope. So in other words, if a law restricts free speech, you give it heightened scrutiny. If the law involves searches and seizures and violates it, give it heightened scrutiny. But isn't that circular? That if something violates the Constitution, you look at it more closely? How do you know to look at it closely unless it violates the Constitution? It's quite circular, right? It doesn't give you very much. But if something that looks maybe like it's violating the Constitution, then you look more closely. Get with me on that one. The second paragraph, though, is where people forget the first paragraph. No one talks about that. But the second paragraph is where all the goodies are. It is unnecessary to consider now whether legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation is to be subjected to more exacting judicial scrutiny under the general prohibition of the 14th Amendment than are most other types of legislation. Kevin, what's going on there?
If it goes against the 14th Amendment, it's going to be...
Read it. Read it again. I'll stop you when I want to. Read it.
It is unnecessary to consider now whether legislation which restricts those political processes...
What does that mean? Legislation that restricts political processes. What are they talking about there?
That if it's something that the legislation wants to run...
What's the political process?
The statute.
No. No. What's the political process? Keep reading. The political process which can...
Ordinarily be expected to bring about the repeal of the undesired legislation.
So what's the political process here?
The legislation or the undesired...
No, David, what's the political process here?
The ability to vote.
And what does voting get you?
The ability to repeal undesired...
Yes, right? So generally, when the government passes laws that you don't like, the way to get rid of it is not to go to the courts. It's to vote out the people who enacted it and vote in new people. But what if the law in question is one that restricts the political process? Right? What if the law makes it harder for you to vote? Or makes it harder for your vote to count? Or messes up districts, for example, so that your vote doesn't even matter? The second paragraph is what's called political process theory. That if some law screws up the political process and makes it harder for you to vote, makes it harder for you to change laws through the representative process, there too, you apply a more exacting judicial scrutiny. They apply a more exacting judicial scrutiny in such cases. Everyone with me so far, right? Everyone with me? When the political process is implicated, it gives examples. On the restriction of the right to vote, restraint on this dissemination of information, interference with political organizations, prohibiting peaceable assembly. So the second paragraph in footnote 4 is all about what's called political process theory, that if there's some law that screws up the political process, there the courts can give it more exacting scrutiny. The presumption of constitutionality is narrowed. Jackson?
Besides the ones that are just listed there, how do they come up with what goes underneath a political process?
Oh man, you got lots of cases on that. I'll avoid your question by saying there are a lot of very difficult cases to find this, but this footnote by Justice Stone was trying to lay out a theory of constitutional law that was very popular for the last 7 or 8 years. Okay, that's paragraph number 2. Now we got to the third one. Okay. And by the way, this entire footnote was only joined by 4 justices in a dictum. And Justice Scalia called these the Carolene products dictumizers because it didn't even get 5 votes. It was a 4 out of 7. It was a shorthanded court. But on to the third paragraph. Again, it says, nor need we inquire whether similar considerations enter into the review of statutes directed at particular religious or national or racial minorities. Wait a minute. Evan, it cites Pierce and Meyer. Were those cases about religious or national discrimination? No, what were those cases about?
There's about whether it's state and religion.
So see, they're trying to reshape the old cases. Those cases have nothing to do with religion at all. Nothing. But they're saying, when you have laws aimed at certain religious or particular national groups, racial minorities, or, and here's the phrase which everyone quotes, whether prejudice against discrete and national minorities may be a special condition. Adam, what does it mean to be discrete and insular? What does that mean?
It's specific.
What does discrete mean?
Discrete is specific, small group.
And what's insular mean?
It's cut off from the general population.
Right. So they mention racial minorities, they mention religious minorities. They say, even beyond that, groups which are discrete and insular, that is sort of cut off from certain circumstances. Right? For such people, if the political process is curtailed, there might be a more searching judicial inquiry. What is that saying? When certain people don't have access to these political channels, there might be an operation for the courts to increase their level of review, to second-guess laws, even if they don't run afoul of the Bill of Rights, right? Even if these are political problems and not civil liberties problems. And it cites McCullough v. Maryland, among other cases. So what's the effect of footnote 4? I'll summarize it for you as the best I can. If you have a law that runs afoul of the first 10 amendments, the courts will give it strict scrutiny. If you have a law that affects the political process, you get strict scrutiny. And if you have a law that impacts certain discrete and insular minorities, you give it strict scrutiny. But what does that say about Lochner? Economic liberty's out. Lochnerism is dead now. Right? Why? Because the right to contract is nowhere in those 3 paragraphs. The right to pursue an occupation is not in those 3 paragraphs. the right to, have a minimum hour law struck down is not in those not in those things. That's why it's very significant that they repurpose Pierce and Meyer as religious and nationality cases when they're not. So the consequence of footnote 4 is they basically chop rights in half. If a right fits within these 3 paragraphs, you give it a very strict scrutiny. If a right falls outside of these 3 paragraphs, you give it a presumption of constitutionality. You give it what's called rational basis review. So this decision in 3 footnotes in a paragraph, 3 paragraphs in a footnote, chopped all of our rights in half. And the next case, which I'll cover very quickly, because it's a very easy case to teach, is Williamson v. Optical, right? This is like a lens crafter place. Second mark. This is like a lens crafter place, right? Where you can go there, you give them spare frames, and they can fit the lenses in for you. It's not very hard. The state said, no, you can't fit frames into lenses unless you're a licensed ophthalmologist or a doctor. And the optical said, wait a minute, this law makes no sense, right? This law makes no sense. Anyone can fit lenses into a frame. It's not hard. Why do you need a doctor there? The Supreme Court upheld it. They say, look, footnote 4. This is not in the first 10 amendments. This is not breaking the political process. This is not affecting the screening of minorities. Therefore, the law is upheld as a rational basis. And that set the tone of how the court reviewed laws limiting economic liberties. So long as the government can make up any reason, any rational basis for the law, that is enough. You only get to a more rigorous form of review when the court finds that footnote 4 was implicated. Mark, patiently waiting.
Oh, thank you. What was like your, what's like you had a title for the second stipulation regarding
political process? Yeah.
Was that rational basis review or?
Well, no. If a law affects the political process, then you go to strict scrutiny, right? You give it a more rigorous review. Okay. Emily.
So, the days when the court would review things that were arbitrary on certain classes or discriminatory or unreasonable, just no more.
No, the opposite. If it's discriminating against certain people, that is, if it fit within those 3 paragraphs, they'll give it rigorous review. But if this was a law involving economic liberty, like Lochner, that was gone. Which is why the question I asked at the outset of today, following the New Deal, the court abandoned the process, right? The answer there is false, because they maintained it in part. You still have progressive era substantive due process when it fits to footnote 4, right? If you can check off any of the boxes in footnote 4, you still keep the progressive era substantive due process. But if you're outside footnote 4, then it's been abandoned. And then you get mere rationality review. So Lochner is gone, right? Lochner's gone. West Coast Hotel's the rule. But there were cases involving civil rights, involving voting, and otherwise, where the court needled in and gave exacting scrutiny. And that's actually basically the summation of today. The theory of Lochner never actually died, right? Meyer and Pierce are basically extensions of Lochner. But the court repurposed those cases to say if it's religious discrimination, if it's nationality-based discrimination, in those cases, the courts will apply an exacting standard review, the strict scrutiny. Otherwise, you're outside of footnote 4, and you're stuck in a rational basis land. And that would be the rule through the Optical, a rule that would change for readings for next class when you get to the sexual revolution cases, right? So basically, Lochner's dead unless it involves a sexual revolution. I'm mostly exaggerating, but for the most part, Lochner died unless it involved abortion and birth control. And that was basically the rule. Because that would prove useful to the court to create rights to autonomy. Questions? Questions? Anything else? No? Thank you all so much. I'll see you in class on Thursday.